Miller, amongst other things. Reflecting that, we have a wonderful event planned for today. Plus, let me just advertise an event here on Wednesday, lunchtime, a lecture to be delivered by the University of Oxford's Timothy Endicott. Professor Endicott will talk on the title of Parliament and the Prerogative, from the Case of Proclamations to Miller. Those of you who are eagerly awaiting next week's oral argument in Miller before the Supreme Court will be fascinated by what Professor Endicott has to say and his explanation for what the High Court got wrong about the prerogative. But the Article 50 litigation raises not only important constitutional questions about the relationship between Parliament and the executive, but also about where the press should draw the line when commenting on judges and the decisions they deliver. It also raises questions about what judges themselves should be saying out of court about cases that are pending before them. These are tricky questions, questions which are trickier because of the changing judicial role. But fortunately, we have a heavyweight panel to help us untangle that complex web of questions this afternoon. They need no introduction, but I'll introduce them briefly in the order in which they will speak. First, Lord Hope, formerly Deputy President of the UK Supreme Court. Before that, Lord Hope was, of course, a law lord. And before that, the Lord President, the senior judge in Scotland. His current role is as convener of the crossbench peers, and for that reason, he'll be dashing off at 2:10 in order to chair a committee meeting across the road. Following Lord Hope is Lord Howard. Lord Howard is, of course, the former leader of the Conservative Party. He held cabinet rank under the premierships of both Margaret Thatcher and John Major. Perhaps most relevantly for these purposes, Lord Howard was Home Secretary. He's also, of course, a barrister by training and became a QC in 1982. Joshua Rosenberg, to my left, will speak third. Joshua Rosenberg is the country's leading legal commentator and journalist. In addition to presenting the BBC's Law in Action radio programme, Joshua writes for a number of stellar publications, including The Guardian and the Law Society Gazette. And then finally, Charles Moore, who was formerly the editor of The Telegraph, The Daily Telegraph and The Spectator. He has a column in The Telegraph on a Saturday, and recently has been, in that column, been exploring some of the issues raised by the changing judicial role. I'll invite each speaker to speak for around 5 to 6 minutes, and we'll then have around 30 minutes for questions and discussion from the floor. Lord Hope.
Well, I hope everybody can hear me. I've got some sort of equipment. I don't know whether it's on or off, but I hope... Can the people at the back hear me all right? Right, thank you very much. Let me emphasize before I say anything that I'm speaking purely for myself. I'm not speaking on behalf of all the judges by any means, so what I say is a personal view, and please take it on that basis. We have two nouns in front of us. One is criticism, the second is accountability, and I thought I would take accountability first, because it's where the process should really begin. Accountable to whom? Well, the judges in our country have security of tenure until, or so long as, if I can use the phrase which was used when the law lords were sworn in the House of Lords, so long as they behave themselves. It was quite difficult to get rid of them if they did not, but security of tenure is a part of the position which they occupy. But of course they are accountable in the sense of being open to public scrutiny. In the 18th century, Jeremy Bentham was very critical of the judges because they used to huddle together in a group. Nobody knew what they were saying or thinking, and the judgments were few and far between. And he complained that this was quite wrong, and they should be open and tell people what they were doing, so indeed they could be accountable. And considerable steps have been made then to open the whole process up to scrutiny. Our judges sit in public, they always give reasons for their decisions, and if you take the Supreme Court just across the lane, they have opened the process up as far as you possibly could, with all their decisions are searchable online. You can see what they're doing every day by television, which I tried to introduce in Scotland in 1992. And there are also means by which, when they give judgments, they're available simultaneously on YouTube. Accountability really is seen by the judges as an essential element of the rule of law. Now, criticism is the other part of the deal. once opened up to public scrutiny, what the judges do is bound to be commented upon. Sometimes what they do is applauded, sometimes it is not. But they have to remember that it is not their job to be popular, to follow the popular line, whatever that happens to be. They're not elected, they don't have to be popular, and sometimes decisions have to be taken which are not popular, especially if they happen to be in favour of minority groups, the disadvantaged or the despised. They should not be carried away by praise when it comes, and they must be prepared to be criticised as well, even when, as so often happens, the criticism is unfair and ill-informed. And I'm talking about criticism not just from the press. Criticism is a fertile field for politicians as well. One of my judgments was said to have made David Cameron feel physically sick when he read it, and we wondered why that was so, but that was a point of criticism of what we said in that particular case. So this is part of the process of opening up yourselves in the way you were encouraged to do. You accept criticism as part of the job, and it's crucial that you cannot and do not answer back. Now, as for the press, which is, I suppose, what we're really thinking about today, we value the free press just as much as we value the independence of the judiciary. So the press are absolutely within their rights to criticise the judges if they wish to do so, but they have a responsibility too. We value the fact that we have a judiciary that's truly independent of the executive, and it's in the interests of the press as much as anybody else that that crucial part of our democracy should be preserved. The judges are the guardians of the rule of law, and you may remember the revolutionary gentleman Henry VI Part II, when he was thinking of how to plot a revolution, he said, the first thing, let's kill off all the lawyers. Let's look at what's happening in Turkey. Now, I'm not suggesting we're anything like that, but if you diminish the judiciary in the eyes of the public, then the executive may feel they can get away with things that may diminish the judiciary too. And things have been happening, and I won't go into the details, which have made the lives of those wishing to come into the judiciary much less certain and much less attractive. And we do run the risk of a diminished judiciary as a result. And it's the support of the executive we need to keep the machinery going as it ought to do. Now, recently, as we all know, the criticism has been taken too far too far, I would say, vicious personal attacks and grossly distorted allegations. I've suffered from this myself on one occasion. Unlike most criticisms, it is quite wounding for judges to be blustered all over the front of a newspaper like that, although they do have the support of their colleagues and they take it on the chin, I'm quite sure. But it's bad for democracy. And also every lecture given by members of the Supreme Court is now being picked over and sentences taken out of context to discredit them before they've even begun to hear the case we're all awaiting. And yet, the Supreme Court judges do give and publish all their lectures on the website as part of the engaging with the public. It's something that I thought we should try to encourage. Instead, we run the risk of closing the thing down, and I know at least one lecture which was taken out in case it did excite that kind of comment, although it should not have done. How to deal with it? Well, I had the situation in a small jurisdiction where I became Lord President after being Dean of Faculty, the leader of the bar at the time of Mrs. Thatcher's great campaign against the professions. Joshua will remember this. We first met when I was Dean, and it was part of my job to engage with the press, and I got to know almost all the editors in Scotland, some of them by first names, before I became Lord President. 3 months after I became Lord President, there was a huge crisis in the press about gay judges in January 1990, when to suggest that a judge was gay, to raise issues about his independence and the possibility of his being compromised in some way. But the story ran on, and they began to say there are more gay judges, 4 or 5. There's a ring of gay judges, and the thing was rapidly out of control, and I had to do something. And I learned then you cannot just say to the press, this is untrue, stop it. So what I did was to gather them together in my room, 20 of them. Some of them I knew, the editors I'm talking about, and I explained line by line what the allegations were and why they were untrue. And in 10 days, the whole story had died completely. So I learned then that the press can be reasoned with. but you need to know the individuals. Now, I don't think that in Scotland today that kind of close contact is still possible, and you'll correct me if I'm wrong, but I don't know that that kind of contact ever happened in England. We had a body called the Scottish Editors who had dinners every 6 months at which they invited me and one other judge to attend. So I think it is very difficult to know how to make direct contact, but somehow the press need to be persuaded to face up to the consequences if they take criticism to the extreme of pillorying the judges, as they did in that particular instance. They did cross the line there, and I hope that somebody somewhere realised that, and it certainly should not happen again.
Thank you, Lord Hope. Lord Howard.
Well, like Lord Hope, I speak only for myself, and like Lord Hope, I will begin with accountability. It seems to me that accountability is at the very heart of our democracy. But in order to be properly accountable, you have to be accountable to someone. Our government is accountable to Parliament. Our Parliament is accountable to the voters. Our press, and I'm flanked by 2 distinguished journalists, is accountable to their readers. And if people stop reading, then they will soon stop writing. The kind of accountability which Lord Hope has referred to, which consists of the Supreme Court and other courts sitting in public and publishing their judgments, doesn't seem to me to be proper accountability at all. Now, I don't say that as a matter of criticism, I state it as a matter of fact. And I don't actually wish to change that position at all. I think the fact that the judiciary is not accountable in any conventional sense is a good thing, and one of the things which goes to the maintenance of its independence. And I'm entirely in favour of an independent judiciary. However, it seems to me the fact that the judiciary is not in any conventional sense accountable to anyone makes it all the more important that it should not in any sense be immune from criticism, however robust. I don't often quote with approval the words of the President of the European Court of Justice. But the President of the European Court of Justice said in an interview a few days ago, if you can't stand the heat, get out of the kitchen. I think that is a maxim which we should all take to heart. Lord Hope said one thing about judges is that they should never answer back. Well, that's a wonderful principle. I'm not sure that it's entirely being observed in these current days. Lady Hale, in her recent lecture, seemed to be getting her retaliation in first, before she sat in judgment on the Article 50 case. I think that was a wholly undesirable thing for her to have done. And there are wider issues at stake here, because what we have seen in recent years is what can best, if rather crudely described, as a judicial grab for power. Lord Hope himself has said that in certain circumstances, legislation is not law which the courts should recognise. Just think about that. Legislation is not law which the courts should recognise. He said it in relation to the Scottish Parliament, when the governing party in Scotland had an overall majority in the Scottish Parliament. You will understand that I hold no brief for the majority party in Scotland. But in saying what he said, Lord Hope gave no recognition at all to the fact that that party had been elected by the voters of Scotland to make the appropriate decisions for the people of Scotland, and for which they are accountable to the people of Scotland. And let me read you something else which Lord Hope said. Both these observations incidentally made in his judicial capacity. He said in a case in 2005, step by step, gradually but surely, the English principle of the absolute legislative sovereignty of Parliament, which Dicey derived from Coke and Blackstone, is being qualified. Qualified by whom? Qualified by the judges, without any recourse to public opinion, without any recourse to our normal democratic principles of decision-making. A unilateral bid for more power at the expense of Parliament and at the expense of government by judges who are completely unaccountable. It would be monstrous if in those circumstances robust criticism of the judiciary were to be curtailed in any way, shape or form. I perhaps might end by saying a word or two about the case of Miller, to which reference has already been made. I have, as you will perhaps have gathered, long been a critical of judicial overreach, but I don't regard the case of Miller as a case of judicial overreach. I think the judges in the case of Miller were applying traditional legal principles. I think they got it wrong, and I hope the appeal succeeds, but I don't regard that as an example of judicial overreach. But in general, when there is at work in the way in which our Constitution is being applied a really large and fundamental argument about the relative power of judges in Parliament, an issue which Policy Exchange, to its great credit, has done a great deal to draw attention to, then I think it is of the utmost importance that the judiciary should not in any sense be immune from robust criticism.
Thank you, Graham. I'd like to begin with this question of whether the judges can answer back. It's taken as read by Lord Hope and perhaps by Lord Howard that they can't and that they shouldn't. I'm not so sure that's right. I'm inclined to take the view that given that the Lord Chancellor's role has been diminished, the Lord Chief Justice's role has been enhanced. And therefore I think it is the duty of the Lord Chief Justice to speak up for the judges. It's more difficult when he's one of the judges who's being criticised, but then it's not impossible for other judges to speak up on his behalf, and we saw his predecessor, Lord Judge, speaking up on behalf of Lord Thomas the other day. It's also true that the Supreme Court judges can respond. They have a press officer, he happens to be at the back of the room today, and he issued statements in response to the criticisms of Lady Hale and Lord Newburger. It's worth, however, picking up Michael Howard's point about Lady Hale and suggesting that she's getting her retaliation in first, and that this is wholly undesirable. The only thing that has been criticised by Lady Hale is one sentence in a published lecture. The context, I'll read you the previous sentence so that you can see the context. The first sentence, which I think is fairly unobjectionable, is she's talking about the case coming up, and she says the argument is that the European Communities Act 1972 grants rights to individuals and others which will automatically be lost if the treaties cease to apply. That was the question before the High Court. She then goes on to say such a result can be achieved only by an act of Parliament, and then the crucial sentence, she says, another question is whether it would be enough for a simple act of Parliament to authorise the government to give notice, or whether it would have to be a comprehensive replacement for the 1972 Act. So she is raising a question which was not raised at the High Court, which may or may not be raised at the Supreme Court next week, an interesting question, a question that she is raising by herself on her own initiative. Now, many people have said it's not entirely wise for her to raise questions that she presumably wants to be considered at the hearing next week, but at least we all know her thinking. I don't think that amounts to prejudgment of the case, and therefore I think that the response on behalf of the Supreme Court is justified. She is simply discussing things. Was it wise? Probably not. Is it damaging? Certainly not. Does it disqualify her from sitting? Certainly not. And as for the fact that Lord Newburger's wife happens to be a former BBC producer who happens to use Twitter to make comments of herself, well, if we were all accountable for what our wives write... Now, Graham, you wanted to ask me, you asked me two questions. Where is the line between appropriate and inappropriate criticism of judges and the decisions they deliver? Does that line need to be redrawn? Now, it would be very easy for me to say, well, the line is a clear, bright line, as the lawyers say. You can criticise their judgments, but you can't criticise them personally. If I were to say that, you would say that surely as long ago as 2007, in the Daily Telegraph newspaper, you published a piece, Joshua, headlined, Mr. Justice Peter Smith loses his judgment. It begins, time has surely come for Mr. Justice Peter Smith to leave the bench. A judge is nothing if he or she lacks judgment, but this is precisely the attribute that Sir Peter Winston Smith, 55, has recently failed to demonstrate. I then go on to say that it's widely known within legal circles that Sir Peter has been having tests for a serious illness. That was the thing that he complained to the Press Complaints Commission about, because apparently he hadn't told anybody else that he was ill, and therefore I had this before him. But he didn't complain about the fact that I said he had poor judgment. And if he had been persuaded by the senior judiciary to stand down nearly a decade ago, then we wouldn't have got into the dreadful situation that we are now in, where he is effectively suspended from sitting and is taking a salary and is apparently suffering from further ill health and is unable to contest the disciplinary proceedings against him, and we haven't heard anything for the past year and a half, and it's all a dreadful situation. Hence my piece in The Guardian on the 17th of June this year, headlined, "Take the hint, Mr. Justice Peter Smith, leave the bench now," and so on. So there is no doubt that it is entirely proper to criticise an individual judge if an individual judge deserves criticism. I briefly refer to Lowell Goddard in this circumstance. Lowell Goddard, as we know, ran the child abuse inquiry. I wrote a piece these days on Facebook saying how she had behaved at the end of July, and a few days later, she too resigned. Perfectly legitimate criticism, although of course she's not a serving judge in this jurisdiction, and I think borne out by everything that follows. So it is acceptable to criticise judges, but that doesn't justify the Daily Mail coverage, which we are all familiar with, the story that was headlined "Enemies of the People." We know how this sort of story appears. I didn't actually read it until quite recently, but you know, for those who only saw the headline, it begins, "MPs last night tore into 3, quotes, out of touch, close quotes, judges for ruling that embittered Remainers in Parliament should be allowed to frustrate the verdict of the British people. The Lord Chief Justice and 2 senior colleagues were accused of putting Britain on course for a full-blown constitutional crisis," in quotes, by saying Brexit could not be triggered without a Westminster vote, and so on, and so on, and so on. Now, of course, the Daily Mail found people to justify those quotes, but it didn't exactly tell the readers how that decision was reached. It certainly didn't explain the point of law involved. Now, we can get on to the much broader question of to what extent judges are influenced by the world about them, by politics more generally. I tend to take the view that they do have a mindset which is to limit the power of governments. That they look at a minister and the Secretary of State, for example, Home Secretary, and they say, well, has that Secretary of State exceeded his powers? Michael Howard and I were just talking briefly about the way judicial review has been extended into proportionality. I was discussing that with another barrister here, and you can say that judicial review possibly has gone too far. But the principle that the judges are there to ensure that ministers keep within the law is an entirely justified principle. It's fundamental to our Constitution, and ultimately Parliament has the last word. Our Supreme Court across the road from here is not the same as the US Supreme Court. The US Supreme Court can overturn legislation by declaring it unconstitutional. Our Supreme Court cannot, and if Parliament doesn't like what it does, then Parliament has the decision. And the question for the Supreme Court next week, just as for the High Court last week, was, do these prerogative powers allow the government, without parliamentary approval, to trigger Brexit? We know what the High Court decided. I was slightly surprised it did, because I was surprised that it was willing to incur the opprobrium that it knew it would incur. But nevertheless it did. It said this was its duty, it had to do this. But if you think about it, it's entirely consistent with the policy that the judges have of trying to keep the prerogative powers under control, discretion given to ministers under control, and ultimately they've batted this back to Parliament. And sure, there will be problems if the House of Lords chooses to delay legislation if the Supreme Court says it's required, but ultimately Parliament is where this decision should be taken.
Thank you. Well, ladies and gentlemen, I'm a bit embarrassed as the only person who's not a lawyer on the platform. I'm obviously at a disadvantage. and my brushes with the law have been unsatisfactory. Many, many libel cases have I had to fight as an editor, and also I have been fined for refusing to pay my television license. So that's about the sum of my encounters with the law. So, but please, that's just declaring an interest or a bias, I suppose. I want to start with a quotation, which is this: "If the policy of the government upon vital questions affecting the whole people is to be irrevocably fixed by decisions of the Supreme Court, the people will have ceased to be their own rulers." Now, that was Abraham Lincoln in his first inaugural address. And the reason he was saying it was because the Supreme Court was defying what Sir John Major calls the tyranny of the majority and backing slave owners. The President of the United States, Lincoln, representing the majority who were against slavery, was taking a different view. And I think that's an important thing to bear in mind about what Lincoln was saying at that point. And I use that quotation to start, and I also use, Michael quoted from Lord Hope, but I also use another one from Lord Hope in the Jackson case. Parliamentary sovereignty is no longer, if it ever was, absolute. And I suppose, to put it crudely, I'm pro-President Lincoln and a bit more anti-Lord Hope. Sorry about that. Now the question really is, why are we discussing this? This is a very important question that will come up today, but why are we discussing it now? And I think in order to understand why we've got into these attitudes and this argument, we need to understand how the judiciary has moved and how the law has moved. And we also need to understand that this is very much an issue in the referendum which we've had. Because one of the fundamental reasons why people voted to leave was because they did not like what Lord Hope was talking about. They did not like the disappearance of parliamentary sovereignty in this country. They did not like the replacement of parliamentary sovereignty with wider forms of authority, whether it's the rules established by the European Communities Act, or whether it's, which is part of that, the European Court of Justice, or whether it's the European Court of Human Rights, which I realise is not part of the European Union, but is associated with the European Union in modern arrangements, whether it's the Lisbon Treaty and so on. A great many people did not like that. I mean, obviously, most members of the British public will not know the details of that, but the question, should we be able to make our own laws, and that should be the end of it, the answer by a great many British people would be yes, and people have sensed that we're no longer able to do that. Now, the referendum was Parliament's solution to this, and the government's solution to it. Parliament endorsing the government. So it was Parliament who was anxious, and the government who was anxious about this problem, and it did something not unique, because we've done it with Scottish referendum and so on, but unusual, which is to pass it directly to the people. And in doing that, though it's technically true that their answer was advisory in the sense that it did not itself have legal force, it was not morally advisory, it was morally a command from the people. This is what should we do? Tell us and we'll do it. That's what Parliament was saying. And now we find, and here I'm asking people to understand the feelings of people who, this is not a legal point, but the feelings of people who voted this way. Now we find that somehow actually, once again, we can't bloody well do it. We are being blocked. We've been asked, we're told that our opinion would bind the matter, and now we're told that we can't actually attain this. And what's particularly galling is that in our defence of parliamentary sovereignty, we're suddenly being told by people who aren't mad keen on parliamentary sovereignty that our decision is against parliamentary sovereignty. So we don't feel very happy about that. We feel that in some sense we're being cheated. And we notice that when there were legal cases against the power of the European Union, such as Rees-Mogg in Maastricht and Stuart Wheeler in the aftermath to do with the Lisbon Treaty, the courts didn't seem to have any trouble there and chucking them out, but funnily enough they seem to be getting very uppity about this one. Now, we also have to understand the political effect, the actual effect, let's say, not exactly political, of the decision of the Divisional Court if it's upheld by the Supreme Court, which is that there will probably be considerable delay. And one of the effects of considerable delay could easily be that we never get this thing at all. And this, of course, is why a great many people who are strongly in favour of staying in the European Union have suddenly got excited in favour of parliamentary sovereignty, because they very much want that delay. So I think all that needs to be understood in terms of why people feel strongly about all of this. So then, along comes the Divisional Court, and it comes to its view. And I strongly agree, by the way, with the implication of what Lord Hope is saying, that the judges do this properly. By that I mean that they seriously try to work out what it is and what the law is, and they are, in that sense, incorruptible, and they're also people of high ability. I think all that needs to be recognised. But nevertheless, I think you have to understand what happens when a whole judiciary and the judicial system, and it's implied by the creation of the Supreme Court, which a concept which was unknown to the English law, and which in my view is a very bad addition to the English law, was developed and introduced in 2009. If you have a Supreme Court, if it starts to say that it can decide things rather than parliamentary sovereignty, at least in some cases, of course it enters the political arena, even if it's entirely without political bias in a personal sense. It obviously must be so. And if that's so, what do you expect if people get angry? And why does it surprise you that people want to know what you actually think about things? Of course, we didn't in the old days have to ask about the judge's opinion about this, that and the other in the way they lived their normal lives, because they weren't venturing into this sort of territory. But if they're the only people in public life who can simultaneously decide our future and not tell us what they think, we naturally want to find out what they think. And so one of the things that becomes very important in all this is appearances. How do the judges behave so that we can trust them in this? And it seems to me that Lady Hale did offend against that in Malaysia. First of all, why was she speaking in Malaysia at this particular point? Secondly, why was she speaking before the, I know exactly why she was speaking. She was giving somebody a lecture to some splendid sultan in Malaysia. Great, but she doesn't have to talk about this particular issue at this particular time. Nor does she have to chuck in the point about the, what's the phrase, Jonathan, that she used?
Another question
complete,
is,
complete.
Whether it would be enough for a simple act of Parliament to authorise government to give notice, or whether it would have to be a comprehensive replacement.
Comprehensive replacement. So she introduced, as Joshua himself said, a new factor which wasn't heard before the Divisional Court, and she chucked that into the mix. And she said that one of the consequences of the Supreme Court existence was that they really are now the guardians, we really have become, she said, implying that they weren't before there was a Supreme Court, they really are the guardians of the Constitution. Now, if you really are the guardians of the Constitution, you can expect people to ask a lot of questions about you, and they could be some pretty difficult questions, and she seemed to me not to think about that. There's the old phrase about the judges being I think it's the lions under the throne, isn't it? Well, one of the things that I'm afraid will happen in the wicked world of politics, media, etc., is that people will ask, are they lions under the throne or are they snakes in the grass? That's only the natural thing. That's the only natural thing that people will do when you get into that sort of controversy. What else would you expect? And you, the judges, have invited that sort of controversy by the way you have extended judicial overreach. By the way, you have gone from a very strict construction of what you ought to be doing to a much broader and more political and more human rights-in, more European idea. What do you expect? And so I think also Lady Neuberger's tweets are important. Joshua says, and I do understand the problem, particularly in his own case, what is one to do about one's spouse if he or she has a career in sounding off and you're just trying to get on with your job? A fair point, but the Supreme Court Code of Conduct makes it clear that this is a very important matter for judges, because most people are not married to judges. It's a different thing. And it says they should always be aware of the problem created by political activity. And Lady Neuberger, I discovered this by this simple device that nobody else had managed to do of Googling her, reading all her tweets. And 50 of her tweets in the last 4 months have been against Brexit and are critical of Mrs May, and she retweeted the point about how Article 50 probably couldn't be triggered without her. On 29th of June, probably couldn't be triggered. So she's engaging in this debate in a public manner, and I'm sorry if the Supreme Court isn't yet aware that tweets are an important feature of public debate, but they jolly well are. And this is political activity. It may not be party political activity, but it is. And the carelessness, and I would say the arrogance to some extent, with which people in these positions feel they can do these things, is bound to have a backlash. It's just absolutely inevitable that it should be so. Therefore, I think it would be appropriate for Lady Hale to recuse herself from the court, and I think it would be for discussion that Lord Neuberger should be asked that he recused himself, which, if you remember, Lord Hoffman had to do in the Pinochet case, partly because he, Lord Hoffman, his wife, was working for Amnesty International, and partly also because of his own involvement in Amnesty International. So I think these are important things. And I think anybody who moves in any judicial circles, and I've occasionally had that privilege of doing so from time to time, will find, as a matter of conversational experience, that the great majority of the senior judges in this country are very pro-European, are very pro the model of human rights, which has now become fashionable, and tend to be highly anti the executive in a way which has not always been true of judges in this country, but is true today, and tend also, quite specifically for that reason, to be rather anti-conservative. I wouldn't say they're supporting any other party, but broadly speaking, that's so. So all of those things raise the sort of sensitivity of this. And I'll just end with this, that one thing we hear a lot about, and Lord Newberger said it only the other day in one of these endless lectures that all these Supreme Court judges give these days, he said that diversity was very important, and he admitted that diversity was a lack in the Supreme Court. And what he meant, of course, was the specific definition that the word diversity has acquired in modern public discourse, which is, are there enough women, are there enough ethnic minorities, and to some extent, are there enough pupils from state schools? Important questions, but not the only question. And I ask another question. Is there enough diversity of opinion in the Supreme Court? If we are going to, the independence of the judiciary should not just mean independence from the government, it should mean independence from one another. Or is it another thing of groupthink that we suffer from in our time, in which they all think the same thing? Is there enough diversity of opinion in the Supreme Court? And can the 17.4 million people who have expressed their view in favour of leaving the European Union feel any confidence that that particular opinion rings any bells with any of those 11 people? Thank you.
Thank you. We've covered a remarkable range of issues, all contentious and all very relevant. If I could invite questions from the floor, I'd invite you to keep your questions short and not too outrageous, and if you could introduce yourself and your affiliation, and I'll take a couple of questions at the same time so we can cover some ground. And the man in the green tie, third row.
John Holbrook. I'm a barrister and I also write for an online publication called Spiked. I think it's worth remembering that judges can only rule on arguments that are presented to them, and the government's presentation of its case was woeful. It was woeful because it disclaimed any reliance on the Referendum Act, and indeed any reliance on the referendum result completely. So the claimants were able to taunt the government by saying your case is that Theresa May could have woken up one morning without a referendum and taken the UK out of the EU. To which the government's answer was, yes, that's a constitutional deficit. Now, that's hardly a promising basis for an argument, is it? You're standing behind a constitutional deficit, and hence you're inviting the High Court to fill it, which they did. Yet the reality is that the government should have recognised the importance of the Referendum Act and the referendum result, so that we could have modernised our constitution with a modest episode of direct democracy by saying, yes, it is quite constitutional to use the royal prerogative on the basis that this matter has been decided by the people. And so the real enemies of the people are actually the government ministers who gave those instructions to the lawyers who then argued it before the judges.
Thank you, John. And a question back here as well. The man in the red tie.
Simon Vile, solicitor. Am I right that Lady Hale implied in what she said in her lecture that the predicate was that prerogative was irrelevant, really, and it was only whether it was one form of Act of Parliament or another? I'd just like clarification on that.
And one last question here before we return to the panel.
Roger Kendrick. We're told that the independence of the judiciary is a fundamental part of our constitution. And independence is fine, but it doesn't necessarily mean impartial. The BBC is independent, but it's not impartial, it's a campaign organisation. And what we have here, essentially, is the people of this country have decided that what they've been told for generations by the establishment isn't actually what life is about, and they want something different. Now, this is a question of judgment, and a judgment is people deciding on something. So I would put it to you that the important thing is impartiality. And one of the things that an impartial judge should consider is something which is different from one of the things quoted in the pleadings, or in the Miller case, and that is the judges know nothing of the will of the people. Well, the judges do know the will of the people in this case, and I think they should follow it.
Yes, thank you. Joshua.
Okay, John Holbrook's point is a fair one, but if the government wanted the referendum result to be binding, the government should have said that when it put the bill before Parliament that led to the referendum. The bill is silent on the consequences of it, and it would have been a simple matter for the government to have said a simple majority, a greater than simple majority, will have the effect that the government has the power to trigger Article 50. It's the government's fault for failing to make that clear in the bill. The second question was, did Lady Hale imply that the prerogative was irrelevant? No, the answer is no. She said quite clearly, the issue is whether giving this notification under Article 50 falls within the prerogative powers of the Crown, or whether it falls foul of the rule that the prerogative can't be used in such a way as to frustrate or undermine an Act of Parliament. That's it in a sentence. She wasn't taking sides. As for the last point, that the judges know nothing apart from what is in an Act of Parliament, that's a perfectly reasonable approach, and it comes back to my first answer, which is that if the government wanted the Act of Parliament to authorise the triggering of Article 50, it should have said so.
Well, that's a very ingenious argument, Jonathan, but when you look back to the debate which took place on the referendum, everybody took part in that debate on the basis that the referendum would decide whether or not we leave the European Union. No one argued in that debate, well, you know, remember, this is only advisory. Everybody assumed that this would decide whether we left or not. And I want, if I may, to take this opportunity of returning to something that you said earlier. You said with a great flourish, Parliament has the last word. Not if Lord Hope has his way, it's not, for the reasons that I cited earlier. Not if Lord Neuberger has his way, it's not, because he wants us to have a written constitution. And the thing about a written constitution is that the judges who interpret that written constitution have the last word. So there is a great and important principle at stake in this discussion, not necessarily in the Miller case, but in this discussion. And it is precisely who is to have the last word. Is it to be our elected representatives in Parliament, accountable to the voters, or is it to be the judges who are accountable to no one?
Well, I just want to reinforce the point about the will of the people. I think the quotation referred to about knowing nothing of the will of the people is from Dicey, isn't it? But,
yes.
But and of course, Dicey must be right that you can't just go around saying, well, this is the will of the people, and you can't even cite an opinion poll or something like that. But I agree with Michael Howard's condemnation of Joshua's point, because if it is true in a purely technical sense that this referendum is advisory, it is not actually an act of law. The decision of the X in the box is not an act of law. But if we had been told, as we went into this referendum, oh, by the way, actually we're not going to act on it, or we're perfectly free not to act on it, you know, people would have been absolutely outraged by that. And it was made perfectly clear, and it was stated specifically by David Cameron, who was advocating a Remain vote, that it would immediately, on the very day, be acted on. He said that we could trigger Article 50 on the day of the result. And so, in all reality, it's just perfect nonsense, that argument.
Can I take advantage of being asked a question, just to go back on one or 2 points, because I'll have to leave a little early. Joshua was saying that I was wrong to say judges can't answer back. What I really meant to say, if I'd been a bit more expansive, was that when I was Lord President, I said to the judges, talk to me, I'll do it for you. Don't attempt to answer back yourselves. And in a way I was doing what you said the Lord Chief Justice should do, and no doubt the Lord Chancellor should do. So yes, I mean, there are people who can speak for them, but the point I was making was that the individual, however bruised he feels, does not and should not answer back. Very difficult, you have to be the Chief Justice yourself, but perhaps he would look to the Lord Chancellor to stand up for him if she could. Now, that's the first point. Michael Howard quoted the words legislation is not law, which is a wonderful example of quoting words out of context, because if you'd read a little further, you could have seen that what I was doing in that judgment in the case of Lord AXA was exploring the democratic accountability and the force of the democratic mandate which the Scottish Parliament has. It doesn't have sovereignty, but it has the support of the democratic vote behind it. And therefore, I said that we as judges should not get into the question as to whether the decisions they took were reasonable or unreasonable or not. The question was, were they within their powers as a devolved legislature? So you're quite wrong. I was actually standing up for democracy there, not at all. But let's take another example. Section 2 of the Scotland Act 2016, which you hope you've read, is going to be an issue, I think, in the Miller case in the Supreme Court, and that says that normally Parliament cannot legislate, Westminster cannot legislate without the consent of the Scottish Parliament in matters affecting Scotland. There is Parliament's sovereignty being diminished by itself in favour of the devolved legislature. Now, what exactly you make of the word normally, and whether the section itself is capable of being applied by the judges is a very difficult issue, and I think we should wait with great interest to see what it is. But you know, there is a general, not criticising Parliament, there are step by step, there are steps being taken which diminish the purity of the sovereignty of Parliament. Lastly, if I may, you're quite right that much depends on the way the cases are argued and what is presented before them. But impartiality, I don't really think comes... Sorry, impartiality is, I think, absolutely plain if judges are dealing simply and solely with issues of law. And that's what they were dealing with in Miller. They made it very clear that's what they were dealing with, a legal issue which was it required to be resolved. There was an answer being called for, and they're the only people who can give it, and they did the best to give the answer.
Thank you. A quick round of follow-up questions. Yes.
Hi there, my name is Seppi Goldsari Monroe. I'm a former civil servant. Thank you very much for a fascinating discussion. I have to say I find it difficult to address this question about judicial power and overreach without looking much more closely at the growing power of governments relative to Parliament. And so I wonder if there could be a few words said about that, because I mean, it's not uncontroversial to say that there's a growing imbalance between government and Parliament, and yeah, if you could address that, I'd be delighted.
In the front row here, on the far left.
Thank you. My name's Anthony Glees from the University of Buckingham. I'd like to hear the panel talk about the principle that underlies the greater emphasis on lawfulness and law. Surely Michael Howard and Charles Moore must be aware that there's a very large number of people in this country, 48%, who voted to remain, as I did so myself, who are also British, and in my case also conservative voters. And why should we trust, quote, the will of the people in that particular way? We believe in lawfulness. Why should parliamentary sovereignty be considered that in that way? Have we learned nothing from the history of European parliaments in the last century to understand that they can become elected dictatorships?
If you can pass the microphone to the gentleman behind you.
Richard Eakins, University of Oxford, and Judicial Power Question. Thank you to the panel for my part too. I wonder about the panel's views of the responsibility of judges to criticise other judges for problematic action. I'm wondering in particular about the dissenting, the force in which judges should dissent in a panel if they do view their colleagues as having
Thank you. If I can invite you to...
Well, I think you're asking a question about dissent, and Lord Neuberger said something about that in a recent lecture. The tradition in the Privy Council used to be that Queen Victoria liked to have a single judgment, and therefore if you dissented, well, that was just too bad. You should go along with the majority view. But the other feature of a dissent is if you want to dissent, you have to write and explain yourself, and there is a certain amount of torpor that creeps in if you wonder whether it's really worth the bother of doing it. I would never instruct other judges not to dissent, because I regard each judge as completely independent, and I never questioned the judgment of my fellow judges. It was entirely up to them what they said or did. So that's a very important aspect of it, and I think free dissent is part of the value of our system. You could see the absence of dissent in the European Court of Justice makes their judgments impenetrable and in some cases virtually useless. So I'm all for dissents, frankly. As for this very interesting question about the will of the people, that's not what Miller was about, and it won't be what the Supreme Court are dealing with. They're dealing with what seem to be now two issues of law that simply require to be answered. There is a question as to whether the prerogative could be used. Some people are saying not, and you've got to have an answer to it from somebody. It has to be the judges, and there is a question about whether the Scottish Parliament and the Welsh Assembly, Northern Ireland as well, should be able to express their views with a legislative consent motion. What the effect of it is may be for Westminster to work out if it happens. But these are important questions, and the only people who can really resolve it in the public interest are the judges.
Well, I just want to deal with the question that the lady over there put, and I completely disagree with her proposition. I don't think it is at all the case that governments have more power at the expense of Parliament. Governments cannot continue in office unless they have a majority in the House of Commons. It's as simple as that. And that majority can choose to exercise its rights at any time and in any way, shape or form, and frequently does. So I'm afraid I completely reject the premise on which that question was based.
Chancellor.
Just to follow on that point, I think one of the things that those of us who voted to leave, we would sympathise with what you're saying. And one of the problems of being in the European Union is that government, in general, does accumulate more power against parliaments, because there is the power of the European Council, and indeed the European Commission, which has no elective basis, can usually outwit the power of each individual member state parliament. Whereas in the United Kingdom, it's pretty difficult for the government to outwit the power, the direct power of the House of Commons. And so that is actually a serious point about the situation into which we got ourselves by our membership of the European Union.
Another round of questions, just right in front of you here.
Thank you very much indeed. Christopher Forsyth from the University of Cambridge. I think the panel has been quite right to isolate the question of parliamentary sovereignty as the crucial one here, in that the question of the last word, who has the last word, is it to be the judges or is it to be Parliament, I think is the vital one. But it seems to me it's unlikely that you'll get a direct challenge to parliamentary supremacy by the judges. What tends to happen far more, and I think is more insidious, is that you will get lip service paid to the supremacy of Parliament, but followed by interpretations of the relevant statute that are strained and unjustified and make no sense at all, but favour the values that the judges would like to see, not the values that are expressed in the relevant legislation. And of course I'm thinking of Evans as an example of that case.
The lady in the back here, and then Dean at the far back.
Hi, I'm Penelope Gibbs from Transform Justice, and I'm going on to issues about transparency raised by Lord Hope, and just the comment really by the panel. I think it is very important that the judiciary is transparent, and I have tried to get a hold of information from the judiciary, and it's not well known, but they're not subject to FOI. So they're excluded from FOI. So I have asked for instance, the annual report on magistrates' training, and that's been refused to me on the basis that it's not for publication or public looking at. And on the transparency point about court judgments, I would say the Supreme Court is good. If you're a Crown Court defendant and you want to appeal your case, you have to pay thousands of pounds for court transcripts. They are not openly, publicly free, the transcript of the Crown Court trial. So I do think we've got a long way to go in terms of transparency.
Thank you, Penelope. And then our Policy Exchanges Director at the back.
Thank you, Graham. Just picking up on Professor Casai's point, and Joshua Rosenberg in a column earlier this year tantalised with the last sentence. He said, I think he said, Parliament is sovereign, but the Supreme Court is supreme. It just, as I say, tantalised at the end without fully explicating. I'd be interested to know what you meant by that. Thank you.
Well, I'm sorry, I'm just about to go. I do come back to the point that there are issues of law that do require to be resolved, and the judges do not initiate these cases themselves. they're presented with cases by parties who are requiring an answer. It's sometimes thought that judges go out into the countryside, as it were, looking for cases to decide that isn't the case. And also on accountability between themselves, I come back to the point of dissent, and I can tell you that in my day in the Supreme Court and in the House of Lords before, there were very vigorous arguments before we actually worked out what our judgment was to be, and sometimes they simply were not capable of being resolved, and therefore there were dissents. So the idea that the judges are just sort of, gentlemen sort of, or indeed a lady too, are just sort of idling along together is quite untrue. These cases are vigorously thought through by the judges after the formal hearing is over. Sorry, I have to go.
Well, thank you to Lord Hope and Mustache. We have 5 minutes more. Do any panelists want to respond?
Okay, I've got to go in a minute as well. I can't. Dean has mentioned a rhetorical flourish at the end of one of my pieces. Unfortunately, I can't remember what I meant. I suspect it was just a rhetorical flourish, but it does come back to the point that is fundamental to all of this, and that is that Parliament is sovereign. Now, Michael Howard talks about the possibilities of a written constitution, possibilities that the judges will then do what the American Supreme Court did and acquire the power or declare the power or assume the power to declare legislation unconstitutional. But we are a very long way away from that. Chris Forsyth says, well, it's about a strained interpretation of statute, and he talks about the Evans case, the Guardian report and the Prince of Wales letters. He may have a point on that case, but this case before the Supreme Court is purely about, can the government do this on its own initiative, or does it require Parliament to pass legislation? And it seems to me entirely reasonable that Parliament should be asked to pass legislation. If Parliament doesn't think it's a good idea because David Cameron has changed his mind from the day after the referendum, or because the House of Lords is going to delay it, or the people want another go, well, that's what parliamentary democracy is all about. And I don't think it is correct to say, as Charles Moore says, that the Supreme Court are blocking this. They are simply giving the means by which this decision of the people is to be put into effect. Politically, fine, it is possible that the House of Lords can, by discussing the bill which we're considering, the government may have to bring forward if the appeal to the Supreme Court is unsuccessful, the House of Lords may delay it, and who knows what will happen in this febrile world in which we now live. But ultimately, all the courts are saying is it's not a decision for us, it's not a matter for our politics or our views, therefore don't matter. It's purely whether these ancient prerogative powers, ill-defined in our unwritten constitution, allow the government to, as is argued by the claimants, overturn the effect of an act of Parliament. That's all it's about.
Well, I agree with Joshua about the Miller case to the extent that I don't think it's an example of judicial overreach, but I do think it was wrongly decided for reasons which I probably don't have enough time to go into. But I think that Chris Forsyth absolutely put his finger on the point. Of course, it's the case that Lord Neuberger hasn't yet had his way, and we don't have a written constitution. And Lord Hope, happily, in some of the judgments to which I referred, was in a minority. But those statements betray a judicial mindset. And that judicial mindset is applied in some of the cases to which Joshua, amongst others, has referred, in interpreting acts of Parliament in a way that Parliament never intended them to be interpreted. That is a danger that we face, compounded by the extension of judicial review, and that is the nature of the judicial power grab from which we are suffering, and suffering because it diminishes the democratic accountability which is at the heart of our historic constitution.
A final brief word from Charles Moore.
I just very much confirm that point about the mindset and add this, that if the mindset were of a different one, the Supreme Court might decide differently from what's expected, because they could put much more weight on Article 50 and why Article 50 was introduced, what happened in the Act of 2008, what didn't happen in the Act of 2011, rather than basing it all on the European Communities Act of 1972. There are a lot of perfectly strong legal arguments here, which would allow them to move in a way which their mindset will probably discourage them from moving.
Well, thank you. Time is the enemy of us all now, so I invite you to join me in thanking all of our panelists for a great